Okay, good morning, everybody. Thanks for joining. We have 512 participants. I can see from the chat box, we have an especially strong representation from the Philippines. So good morning and welcome everyone from the Philippines. Minus you obviously have a big fan club there. They've all turned out to hear you speak.
Yeah, I invited all of them.
They're all here, and from Indonesia as well. And I think we had people from 40 countries registering, everywhere from Afghanistan, Bhutan, Brazil, Cambodia, Colombia, Solomon Islands, US, Vietnam, so Norway, Austria, Tajikistan. So we have a very international crowd. I'm just checking to see. I know that we just had a technical problem getting our moderator into the right Zoom room. I'm not sure if we've solved that yet. So we might just have to hold on for just a minute. Okay, well, it's 10 o'clock Bangkok time, so I'm going to start. I'd like to welcome you all to the first in our series of 2020 webinars from the ASEAN Judicial Integrity Network. The ASEAN Judicial Integrity Network is a partnership between the judiciaries of a number of ASEAN countries, including Indonesia, Malaysia, Philippines, Singapore, Vietnam, Thailand, with the support of UNDP and the further support of the US Department for International Narcotics and Law Enforcement in the US State Department, and the UK's Prosperity Fund, and specifically the ASEAN Economic Reform Programme. And for the first time this year, because of the changed circumstances, we are moving our format to a series of webinars, and this is the first of this year's webinars. And appropriately enough, the focus of this webinar is on the challenges caused by COVID-19 for access to justice, to make sure that since justice delayed is justice denied, how are our ASEAN partner judiciaries working to ensure that justice is done and seen to be done even in COVID-19 times. And I'm very happy to have with us an all-star panel of judges, court administrators from our partner jurisdictions, and especially the presence of our chief guest, Chief Justice Menon from Singapore. And so I'm just going to start with my name. I should introduce myself first. My name is Nick Booth. I'm an advisor on human rights and access to justice in UNDP Bangkok Regional Hub. And I'm just going to give you a little bit of housekeeping to start out with for everybody. So because we have 512 people, if you have questions, please post them in the Q&A section. You can find a little Q&A button on the bottom of your Zoom. That way, we will see your questions. Everyone else will see your questions. You can vote questions that you particularly like. And so please do that rather than asking the same question. And then the more people who vote, the more likely it is that we'll be able to select that question to pose to our panelists later when we have the Q&A session. If you have other issues, by all means, please post them in the chat and we'll see them there. It's great to see people from, I mean, I know we had registrants from over 40 countries around the world. It's great that we have more than 500 people on this webinar. That's extremely exciting. It shows the great level of interest around the world, and especially in our region, to make sure that justice can still be done in times of COVID. We are recording this session. I hope that's okay with everybody, so that we will be able to make it available to people who couldn't join us. And we will send you the link to the recording after this seminar, together with a feedback form and details about the other seminars in this section. And I hope that we've sorted out the issue about Vietnamese interpretation. If you want to listen to the Vietnamese interpretation, you should go to the interpretation button on the bottom and click Russian. And I'm sorry that you have to click Russian because it didn't have a button for Vietnamese. So we had to pick one of the other ones.
I'm sorry for interrupt, Nicholas, but I don't know if you still can hear me because I mute myself just now and now I unmute. So everybody start to hear me right now?
Yeah, I'm afraid I can. So I don't know what we're going to do about the interpretation issue. We have to sort out the interpretation issue. We haven't found a way. We haven't found a.
I'm trying to. What if we have to select English? If we just want to hear very normal English?
Well, the trouble is I have selected English, and
Okay.
Mr. Hiep, you've selected Russian, have you, as your channel?
Yes, I select Russian already.
You see, he selected Russian and I've selected English, but we can hear each other.
Okay, so I'm gonna mute myself right now.
Now, I mean, I pressed a button that said mute original audio, but I suppose that means, can the rest of you hear me now?
Yes.
Yes.
Okay, that's interesting. So, Mr. Hiep, can you hear me now?
I can hear you, but I'm afraid that if I speak,
So
if I
now
start my
I can't
translation,
hear
everybody.
Mr. Hiep, but I can hear
okay,
Midas, and Midas can hear me, right?
Yes, I can hear you, Nick. I can hear you, Nick.
Okay. So what seems to work is if everybody goes onto their interpretation button, clicks English, unless they want to hear it in Vietnamese, in which case they click Russian, and then they have to click mute original audio. And when that happens, so now Mr. Hiep, you can,
yes.
If you speak, I can't hear you, I think. So
okay,
say something,
perfect.
Mr. Hiep.
Okay, so now I will start my translation because no one. Okay,
so now
perfect.
it's working for me as it should.
Okay, okay.
Can the rest of you hear Mr. Hiep at the moment?
Yes.
Yes.
No, I can hear you, Nick, but I can't hear Mr. Hiep.
Okay. And did you mute your original audio?
I did exactly what you said. I put English on my translation button and I original audio.
We are learning by doing, because this is the first webinar we've organized with simultaneous interpretation. So thank you for bearing with us. We are pioneers. And in all experimentation, there's a little bit of learning by doing. So if everybody could please go to the interpretation button at the bottom and do what I just said. Select the English channel if you would like to listen to this webinar in English. Select the Russian channel if you would like to listen to the Vietnamese translation, and mute the original audio. And I think that should work. With that, I would now like to pass over to our honorable moderator, who is Justice Shirani Tilakawadane from Sri Lanka. Justice Tilakawadane, I believe you are online. May I please hand the baton over to you?
Xin mời thẩm phán Shirani có thể điều hành phiên làm việc của chúng ta sáng ngày hôm nay. Cái phần vừa rồi cái kênh phiên dịch nó hơi có vấn đề, cho nên là hơi mất thời gian một chút, và bây giờ xử lý xong rồi. Bây giờ mình sẽ theo dõi.
Okay, now I heard the Vietnamese again for some reason.
So now you hear me, Nick?
Yeah.
Nick, we lost the interpretation button for some reason. That might be why.
Yes,
I don't know.
yes, I had the same thing. My screen changed, I lost my interpretation button, and I started hearing Hiep again. So,
Nick, can you hear me clearly?
Yes. So
okay, I'm going to start. I'm going to start because of the time factor. Okay.
Please start, Shirani, and then Wei will sort out the interpretation issue separately.
Yes. And can you knock off the other mics because it's interfering with me, right?
Yes. So everybody else, please mute. Thank you very much.
Yes. Good morning, everybody. I know we're talking about some.
So.
I can't hear that.
It was an assumption that in every contribution, there will be a learning curve for all of us. Something innovative, something positive, a take-home experience.
Với cái tình hình mà đại dịch COVID-19 hiện nay thì rõ ràng
The purpose of this webinar is to engage in lateral learning through our region so that we may all individually and collectively. And despite the seemingly insurmountable barriers and challenges we face through the COVID-19 pandemic and its destructive aftermath, ensure that there would be no weakening or degradation in the service we the courts offer through the rule of law and its institutions that administer justice. We will emerge with courage, stronger, and with greater relevance to the nation of people that we serve, all the while upholding the core values of justice. We as judges and stakeholders being able to cope to the users of our courts and institutions, that we would continue to work with indisputable integrity by holding the core values of all judges in the globe, the 6 values of independence, integrity, impartiality, and working with diligence and competence and with propriety, always forging forwards and upwards in our desire to give equal and full justice to all those who seek the powers of our system of justice to register their pain and obtain equal and substantive justice. Now, it is my very great pleasure to invite our first speaker, the Chief Justice of Singapore, the Honorable Sundaresh Menon. I will be very particular about timing, I'm afraid, because that has been a command and that I have been held to by Nick, who is organizing this. So I will be, I think when you have been given your time allocations, and you will kindly keep to those because when you take even 1 minute longer, it impinges on the other person's rights. And as we're all upholders of human rights and the rights of everybody else, may I now invite with great pleasure, Chief Justice Honorable Sundaresh Menon.
Thank you, Justice Tilakawardena. Good morning, and let me begin by thanking Nicholas and the Judicial Integrity Network in ASEAN for organizing this webinar and for inviting me to join you this morning. In a time of unprecedented restrictions on international travel, I think it is more important than ever that we keep our channels of communication open and candidly share our experiences through forums such as this webinar in addressing the common global challenge that is COVID-19. Because of its open borders and international workforce, Singapore was one of the first countries affected by COVID-19. In order to decisively break the chain of transmissions, the government announced a series of stringent measures which were likened to a circuit breaker on 3rd April 2020. This involved the closure of most workplaces, leaving only essential services and key economic sectors operational. Originally planned for a month, the circuit breaker period was later extended all the way to 1st June 2020. When the circuit breaker measures were announced, the first priority for the judiciary was to ensure the health and safety of all judges, court staff, legal practitioners, the public, and the media. We therefore announced on 5th April 2020 that we would hear only essential and urgent matters during the circuit breaker period. All other matters would be adjourned. Over the past 7 weeks, we have implemented solutions to hear and manage cases without the need for any physical attendance in court. This has allowed us to keep the courts open for litigants who have the most critical and time-sensitive justice needs. For our judiciary, the past few weeks have been as instructive and formative as they have been challenging and at times exhausting. This morning, I will share a few of the key lessons we have learned and the upcoming challenges that we foresee. I will then end with 3 short reflections on the likely impact of the pandemic on the future of the courts and the legal profession. Let me begin with a sketch of 3 essential learning points. First, the pandemic has delivered a striking warning against any complacency in business continuity planning on the part of courts. I mentioned earlier that our first priority was and is the protection of all who are involved in or concerned with the administration of justice. In order to achieve this objective while continuing to function at an essential level, we had to quickly and dramatically change our ways of working. That would have been a formidable task without a business continuity plan in place that was cogent, practical, and well-tested. Fortunately, our court management team has had a fairly robust business continuity plan in place for a number of years, and that was the foundation on which we built our response to the pandemic. Second, even the most carefully curated plans will be ineffective if they're not relayed clearly and in advance to those affected by them. In times of crisis, it is essential that courts convey their intentions as early as possible to stakeholders such as the bar, the Attorney General's chambers, and court users, so as to permit feedback, establish common expectations, and offer as much reaction time as possible. To this end, at each stage of our planning process, we actively consulted the Law Society and the Attorney General's chambers. Their feedback and support were instrumental to our ability to respond coherently to the unfolding crisis. Third, events of the nature and scale of COVID-19 are generational events that impose a major stress test on our justice system. They therefore represent valuable learning opportunities that we must maximize through careful review and reflection. The aim in particular is to identify those organizational weaknesses that might have quietly crept in over the years, but which the stress of the crisis has now laid bare. For a pandemic of uncertain duration like COVID-19, it would have been foolhardy to defer that process of reflection till after the storm had passed. We had to learn our lessons as we lived these experiences in order to improve our subsequent responses to the ongoing crisis. And so a few days into the circuit breaker period, we formed a strategic planning group consisting of the leadership of each court. The group has been and will continue to carefully review the measures we are implementing, examine the challenges that our courts are likely to face in the coming months, and explore how we can build on the advances we have made during this period to further improve our justice system. COVID-19 must become the occasion to reforge and refine our processes of administering justice. Let me turn to three of the major challenges that I think lie ahead for our courts and likely also for many courts around the world. As lockdowns ease and courts gradually reopen, the immediate challenge will be the disposal of accumulated and incoming cases. Accumulated cases are those that we were hearing or managing before our services were curtailed, as well as new cases filed during this period. Clearing this backlog will be a pressing concern for all courts. We should also be alive to the real prospect of a surge of new cases in the wake of the economic devastation caused by COVID-19, especially in areas such as insolvency and bankruptcy, claims for breach of contract, which will encompass issues of force majeure, construction disputes, mortgagee actions, and family disputes, in particular maintenance claims and domestic violence cases, as the pandemic and lockdowns take their toll on family finances and fundamentally reshape our living environments. Our court's immediate response to the anticipated backlog and new work will likely involve a three-pronged approach. First, optimizing court hearing days and judicial resources. Second, developing processes to expedite the disposal of cases and adopting a more active approach to case management. And third, encouraging mediation and settlement. For example, active case management might involve prioritizing the hearing of interlocutory applications upon which the progress of a case is critically dependent, and exploring documents-only hearings where parties consent to dispense with oral evidence. Yet even as we turn our attention to addressing the problems left by the pandemic, it is critical that we commit to safeguarding the health and wellness of our judges, our staff, and the legal profession as they have to cope with heavier workloads and adapt to new working conditions and processes. It would be false economy to focus on clearing the backlog at all costs without ensuring that whatever measures we take are going to be sustainable. This leads me to my next point, which is that the challenges we face will be compounded by the fact that COVID-19 is expected to persist as a threat in most societies. and thus some restrictions on movement will likely be a reality for some time to come. This presents a considerable obstacle to many long-standing practices of the courts and the profession, such as the liberal use of hard copies, the filing of multiple applications and documents, and the tendency towards lengthy oral submissions. These practices seem woefully obsolete, unrealistic, and even dangerous in the new paradigm of safe distancing and crowd controls. I suggest that the solution to the growing caseload cannot consist solely of hard work using conventional tools. Instead, this is the time for us to think boldly and innovatively about how we hear and manage our cases. We should explore ways to simplify, streamline, and even completely transform processes that are too slow, laborious, and expensive. Among the ideas we are exploring are, for instance, the use of fast-track procedures, paper hearings, shorter form judgments, specialized lists, simplified discovery, and template forms and affidavits. In addition, the pandemic has been a watershed in the partnership between justice and technology, particularly in light of the dramatic rise in the use of video conferencing technology. The pace of the technology revolution in justice over the past few weeks has been nothing short of astounding. As Professor Richard Susskind has noted, and I quote, "Until a few weeks ago, most judges and lawyers rejected the idea of non-physical courts, denying that remote hearings could be fair or even technically feasible. Then the virus came, courts closed, and it only took a fortnight," end quote. In all of this, necessity has been the mother of invention. But I suggest that courts must harness this momentum to contemplate even more fundamental ways in which court services can be reshaped by technology, such as asynchronous hearings and the provision of remote assistive services to court users. At the same time, while we continue to integrate technology into court processes, we must remain aware of the special needs of litigants in person, or LIPs. LIPs are often legally untrained and therefore unfamiliar with the legal system and its processes. This challenge can be exacerbated by the fact that many also lack the equipment or know-how to use the court's electronic services. This means that while courts pursue digital transformation, they must also support these LIPs to ensure their effective access to justice. This was a particular focus for our family justice courts, or FJC, during the circuit breaker period, since many of their users are LIPs. Concerned that LIPs might be unable to use video conferencing technology such as Zoom without assistance, the FJC undertook to train users in the use of Zoom and even issued a technical guide on how to use it. The FJC also established 14 Zoom rooms in 2 locations, each with a Zoom connection to the relevant family judge, so that LIPs unable to set up a call on their own could visit these rooms to attend hearings. About 30 to 40% of the FJC's users attended hearings from Zoom rooms during the circuit breaker period. This enabled FJC to hear about 33% of their caseload, or more than 2,400 cases, during the circuit breaker period, in spite of the movement restrictions. Let me conclude with 3 short reflections on how COVID-19 is likely to transform, perhaps irrevocably, the approach of the courts to the delivery of justice. First, I join the growing chorus of predictions that the conduct of hearings by way of remote communications technology is likely to become commonplace and perhaps even the default modality for most hearings. This technology has proven its worth during court closures, particularly for short hearings at case management conferences. As courts further explore the use of remote hearings, they will also need to improve electronic filing and case management systems, and perhaps work towards the laudable goal of an entirely paperless environment. They must also navigate a raft of new issues, including safeguards for the taking of evidence in remote hearings, concerns regarding the use of remote hearings for criminal matters, issues of cybersecurity, and the need to sustain open justice by ensuring reasonable access to remote hearings for the public and the media. Second, in their search for solutions, courts must also bear in mind that they are operating within a radically different external environment. Public funds are likely to be under pressure for some time as governments devote their resources to containing the pandemic while keeping the economy afloat. This will call for efficiency, proportionality, and fiscal prudence in the delivery of court services. In addition, conditions for the legal profession will likely be vastly different after the pandemic. Clients are likely to be cash-strapped and far more inclined to renegotiate contracts than to be entangled in costly and protracted court proceedings. This could place downward pressure on legal fees and in turn affect the sustainability of law firms and their willingness and ability to engage in pro bono work. While society's demand for legal services might decrease during this period, the same may not be true of the volume of its legal needs. In particular, we may see growing legal needs in the segments of society that are least able to pay for legal services, such as families in distress who need relief from the courts, small businesses that need help to raise finance or restructure their loans, and individuals in dire financial straits who turn to crime and must then face the consequences. The gulf between society's legal needs on the one hand and its ability to pay for the required services on the other, coupled with law firms' reduced ability to help bridge that gap through pro bono work, is a real concern. I believe it is incumbent on courts to lead the discussions on how we can secure and promote the administration of justice in these conditions, and that this must begin with courts re-examining their role and function in a society altered by the pandemic. More specifically, I suggest it will not be enough for us to maintain our traditionally reactive role in engaging with court users and those with legal needs. Rather, we must be far more proactive in providing information and assistive tools to help court users understand their options, guide them through the court process, and promote amicable settlement. In the post-pandemic world, this could prove to be an important way for us to help nurse our ailing societies back to health. My third and final point concerns the need for courts to augment their efforts to promote the amicable resolution of disputes, which I've just alluded to. Judges should actively encourage parties to consider settlement, especially in situations where litigation would be wasteful, destructive, or otherwise do more harm than good. This would, of course, help in the clearance of backlogs, but more importantly, mediation is often a swifter and more cost-efficient means of resolving disputes. It also offers the possibility of more varied and creative solutions than court remedies. And perhaps most valuably, it promotes reconciliation and the preservation of relationships that can be worth more than any legal remedy. Thank you very much.
Thank you very much, Chief Justice Sundaresh Menon. You did us a great favor of sticking absolutely to time. In fact, you had a few minutes more and you have, therefore, I think we can move on to the next speaker with that advantage which you gave us. And I think mostly I want to thank you for the outline that you gave, the model that was both inclusive, and therefore you set us a paradigm which I think all the other speakers would be able to easily fit in. It was comprehensive and it was instructive. Thank you once again, Chief Justice of Singapore, Honorable Sundaresh Menon. And now, almost dead on time, we have another interesting speaker for you. Actually, the only woman on our panel, and that is the Vice President of Jakarta High Court, Indonesia, the Honorable Judge Adriani Nurdin. May I introduce you to speak and remind you that you have 12 minutes. Thank you.
Thank you. Good morning, ladies and gentlemen. As we know that the status of certain emergencies due to the pandemic has an impact on the implementation of judicial process. Government of Indonesia has taken various measures during the corona pandemic. However, the judicial process must continue. This pandemic situation forced public service institutions such as the court to make adaptation to work and service rules, which are implementing work from home policy and providing online public service. 2 years before the pandemic in 2018, the Supreme Court launched an electronic case administration service for civil matters known as e-court. This service enables litigants to register cases and pay court fees online without having to go to the court. This service also applies to summons for litigants, so that the court clerk doesn't come to the residence of the litigant to deliver the summons. Bailiff simply sends the call being linked to the electronic domicile of the litigant. In 2019, the Supreme Court has again upgraded the e-court services so that its online services are expanded not only to administration, but also to online trials. This electronic trial service allows trials that can be done by online. Attendance at court is only during evidentiary proceedings. And the court policy during COVID-19, the Supreme Court and the Constitutional Court switched to virtual trials. March 2020, this is transition period, the lower courts were still allowed to conduct selected trials offline. To conduct selected trial offline with restricted attendance at hearings and temperature scans for all attendees before they were permitted entry. 13th April 2020, all lower courts were using the Zoom video conferences platform. For criminal cases, a joint agreement with the Attorney General Office and the Law and Human Rights Ministry was established in late April 2020. The Attorney General Office issued an Attorney General's instruction on optimization of the implementation of duties, function, and authority in the midst of COVID-19. One of the points of which is to conduct criminal hearings by using video conferences. The Supreme Court of the Republic of Indonesia issued a policy regarding criminal case hearing by teleconference. And the Ministry of Law and Human Rights issued a regulation of prevention, handling, and control of the spread of COVID-19 in prison. One of the points of which is that hearings can be carried out in prisons, open to the public through internet media, or by conducting teleconference hearings. During the pandemic, number of cases registered through e-court for civil cases and normal administration procedure for other cases from January to May 2020 are decreasing. It is estimated that people are postponing litigation in court due to the pandemic situation and the arrival of Ramadan, fasting months. So, and Jakarta High Court during COVID-19, based on circular letter of the chairperson of Jakarta High Court Policy on Prevention of COVID-19 spread in Jakarta High Court and District Court in the jurisdiction of the Jakarta High Court, stipulated that during the emergency period, the regulation on duration or time limit for the settlement of the case doesn't apply. Until the emergency period ends, the hearing schedule was adjusted to the schedule of the judges and clerks working at the office. Normally, time limit for settlement of civil cases is 5 months for first instance court and 3 months for appeal court. For criminal cases during COVID-19, where the defendant is being held for trial are conducted through a teleconference. The indictment was read out before the judge, registrar, public prosecutor, and defendants in the courtroom hearing the case. The defendant, and the defendant's lawyer in the courtroom hearing the case. The defendant is in a special detention room equipped with teleconference facilities so that the reading of the indictment is heard by the defendant and she or he can determine his or her response after communicating with his or her lawyers whether to submit an exception or not. Witness examination is carried out by witnesses being heard in court hearing by the defendant, who is in a special room in the state prison detention center. The defendant's examination, reading of the claim, reading and reading of the decision were carried out by the teleconference. If there is no teleconference facility at the state detention house and or correctional facility, the trial will continue to be carried out normally. It's been not by teleconference. Adjournment of the trial and limitation of visitors to the hearing are the authority of the panel of judges to determine. The panel of judges can limit the number of visitors to the hearing and applying social distancing between visitors. The panel of judges can order the detention of body temperature or prohibit physical contact such as shaking hands for parties who will be present at the hearing. The panel of judges and parties in the trial use protective equipment in the form of masks and medical gloves in accordance with the conditions and situation of the trial. Challenges. The government's policy on large-scale social distancing policy is a challenge for the lawyers of the defendant who resides in another city to attend this meeting. This affects that public prosecutor and defendant who were detained in detention halls. Also, witnesses who were summoned were not present due to afraid to being infected. Challenge in anticipating delay in criminal court due to the most of the defendants are in custody and there is a maximum period of detention that must be considered. The challenge in conducting a court hearing for juvenile cases by teleconference is to ensure the psychological support for the child during the hearing. Can this need be fulfilled through a physiological remote assistance? For the recommendation, we need a revision of the criminal procedure code. Need to be revised to accommodate emergency situation. And the Supreme Court is to tackle facilities issue as one of the priority issues of the court modernization, including engaging with other institutions such as Attorney General Office and Ministry of Law and Human Rights. And thank you for kind attention.
Goodness me, how perfect timing that is. Once again, I'm amazed at this team. Thank you so much. We really enjoyed your presentation about Honorable Nurdin. It is about Indonesia and the problems you're facing. And I remembered in the background paper, you have said that there would be, maybe there would be objections, but that would have to deal with it in the interpretations in the Constitutional Court about the witness, the way they give evidence. And thank you for that comprehensive thing where you dealt with women and children and issues that how you have taken steps to also deal and include them in providing and crafting for new methodologies. And now we have 1 extra minute, which we can pass on to the next speaker. And it is my privilege and pleasure to invite the Chief Judge of the High Court of Malaysia, the Honorable Tan Sri Azhar Muhammad. Thank you for coming in, and I know that you have been, we are all waiting anxiously to hear what you have to say, and may I now invite you to make your presentation. And you too have, actually you have 13 minutes left to speak. Thank you.
Thank you, Justice Shirani, and a very good morning to all of you. First of all, I wish to thank the organizer for kindly inviting me to participate in this seminar. I welcome the opportunity to share briefly with you the challenges faced and lessons learned by the Malaysian judiciary in the times of COVID-19. Following the Malaysian government declaration of the Movement Control Order, which is our own version of a lockdown, almost all Malaysian courts were closed starting from 18 March 2020. This has resulted in a far-reaching implication in the operation and administration of our justice system. There was concern that the lockdown would have severe impact on the accused person's right to a speedy trial, some of whom were remanded in prison pending trial. From the business point of view, billions of dollars of debt that goes through the court process will not be able to be collected. But in these extraordinary and unprecedented times, it is unrealistic and impossible for us to operate in the usual way. Physical attendance in court would be harmful to the public health and safety. Indeed, the pandemic is exposing the limit of open court justice. Our usual methods of proving legal services and managing our professional relationships have to adapt to entirely new norms and expectations. Our immediate step, therefore, was to postpone all trials and hearings. At the same time, we remain committed to our constitutional obligation to ensure continuous access to justice to members of the public. The administration of justice cannot come to a grinding halt and come to a standstill. To this end, a limited number of courts continue to operate, although with a more limited scope. In maintaining law and order during the lockdown, the magistrate criminal courts across the country still hear remand and bail application, as well as fresh charges, including cases related to domestic and other gender-based violence. Moving now to the civil and commercial cases. Fortunately for us, the e-filing and the e-review system have been up and running for many years. The e-filing system enables the online filing of documents continues to operate and process as usual during the lockdown. To ensure hearings in civil and commercial cases can still proceed, we were looking at solutions out of necessity. We subsequently expanded the use of our existing IT infrastructure to conduct remote hearings for hearing of these matters. 3 routes were available to parties who apply. First, the exchange of mails, e-review system, and the video conferencing. Urgent ex-parte applications, such as for interim injunctions, were conducted by way of exchange of emails between the court and counsel. E-review application was fully utilized for case management and pre-trial conferences. Video conferencing hearing as a start were confined to applications filed together with a certificate of urgency. Later, it was extended to uncontested applications, brief interlocutory applications, and hearing of interlocutory appeals. In terms of ICT infrastructure, we are ready to conduct these remote hearings. In the current challenges that we are facing, it motivates us to move even faster in adapting technology to deal with the fallout of the pandemic. For example, on the 23rd March this year, we took a big step forward when for the first time, the Court of Appeal and the Federal Court later conducted civil appeals by employing video conferencing technique. A few months ago, before COVID-19, it would have been inconceivable for both our Court of Appeal and the Apex Court, replacing face-to-face hearing with video conferencing. Traditionally, we meet in one physical location. But in the face of this crisis, we are developing a new mindset that will change our conduct of hearing and trials and the way we function as an institution. This is how life is changing after COVID-19 in our justice delivery system. But however, hearing by way of video conferencing was conducted subject to parties' consent, as we do not have specific legislations to conduct remote hearings. As a result of a combination of many factors, we have limited success in asking lawyers to have their matters heard by way of video conferencing. In this context, to have a more structured regulatory regime on remote hearings, steps are now underway to amend the relevant laws to give effect to the conduct of online hearings. The new legislative framework will give the courts the necessary power to conduct remote hearings when public safety is of concern, as opposed to make it by consent of the parties. Let me now say a few words about our experience and approach to reopening our courts. As the government begins to gradually ease the lockdown, we have created a methodology by which our courts reopen gradually in 3 phases. We are balancing open justice with public health concerns. It is a very delicate balancing act. At this moment, we are not rushing back to trials and hearings in open courts. It will be a slow and cautious reopening. Public health and safety remains our paramount considerations. With this in mind, we have drafted a protocol to conditional reopenings of courts. And if you are interested, you can read it, the detail of this protocol in the background paper that I have circulated. This protocol was drafted with a view to achieving an acceptable level of physical distancing and to minimize the physical appearances of court users in the courts. Our aim is to keep the court safe and secured to prevent the spread of COVID-19 infections. The first phase of our reopening is with effect from 4th May this year, where a number of court services began to resume operations fully. Subject to the new business order, among the services fully operational from this date include the registration counters, power of attorney counters, and commissioner for oath counters. But during this first phase, courtrooms, however, remained closed. The second phase, where we are now, is from 13 May until 31st July 2020. For this second phase, we set a timetable for a phased reopening of the courts across the country in several stages. Our decision to reopen the courts did not mean we would operate at full capacity immediately. Initially, only a limited number of courts were allowed to operate on a rotational basis. The number of cases in a given courtroom in any one session was reduced. Judges were required to start their open court hearing at staggered time instead of everyone congregating at a particular time. For judges who were not sitting, we put in place a more flexible working setup. They and their supporting staff were required to work from home and continue to conduct remote hearings where possible. The third phase, after 5th July, is less certain. Depending on how the COVID-19 situation then develops, in the third phase, we hope that given a sustainable situation, all the courts will be allowed to resume regular hearings with effect from 1st August 2020, subject to strict health management practices. The courts we left before the lockdown was somewhat different when we returned on 13 May 2020. The reopening of the courts on that day, subject to the protocol, saw a returning to a new normal. In a reminder that getting back to normality could not be easy, judges and court staff were required to have their body temperature taken at the point of entry before they report for work. Court users had to line up via a single entry point before entering the court building. They were required to complete a form for social tracing purposes if the need arises. With the social distancing rule being observed in the courtrooms, seating arrangements had been reconfigured. Lawyers now were not seated right next to each other. Instead, there was one space between them, which required the court to drastically reducing seating capacity. And in the courtrooms, everyone was encouraged to wear protective face masks. These are a few of the new normal that all of us have to grapple with. On the bright side, the reopening of the courts amid heightened precautionary measures have been smooth so far. Early indications indicate that the court users are showing high compliance with the requirements of the protocol. The feedback received from our judges and court users have been positive. We have learned a lot from this COVID-19 crisis. And in closing, I want to highlight some of the valuable lessons. The first lesson that we have learned is that we must be better prepared for future disruptions. The sudden and unpredictable nature of COVID-19 called for a rethink of how we deliver justice in such a situation. Hopefully, COVID-19 will in time pass, but the pandemic could be long-lasting. And in this context, it is important for us to take notice of the warning of WHO that the virus may never go away and that it may become just another endemic in our communities. What this all points to is that we have to learn to live with it and continue to adopt and adapt in discharging our judicial functions. Secondly, the disruption from COVID-19 outbreak has forced us to change the way we conduct our trials and hearings. Now, more than ever, in this new environment, digital transformation has never been more important now to prepare our courts. Remote hearings are here to stay. Generally, there is now a recognition that court litigations can be resolved fairly by remote hearings. This may be the new form, the new norm brought on by COVID-19, and for the near future and for some time to come, I think the court will demand greater use of remote hearing. Thirdly, looking into the future, the judiciary must continue to invest in new technology and equipment as we turn to technological advancement to conduct hearings remotely and ensure the wheel of justice continue to turn during a crisis such as this pandemic. We must also continue to upgrade our system to address against all security threats or concerns. And finally, to the legal practitioners, they must sharpen their ICT skill and knowledge to conduct remote hearing and trial. They must equip their law firms to cover cloud computing, online research facilities, and remote access to files and documents from home. It is necessary for lawyers to adjust to this new normal and remain steadfast in adopting the available technologies. If they pay no heed to adapt to these new realities and be ready for the long haul, they will be at a disadvantage and left behind. And this will have an impact on equal access to justice for litigants. Thank you.
Thank you, Chief Justice of Malaysia, Honorable Sri Azhar Mohammed. Thank you so much for your informative presentation. I now move on to somebody we as judges would be lost without, a court administrator. And he comes from the Supreme Court of Philippines, the Honorable Jose Midas P. Marquez. I welcome you, and your time limit is exactly 12 minutes. Thank you.
Thank you. Let me first quickly acknowledge our distinguished speakers in the order that they spoke. Chief Justice Sundaresh Menon of Singapore, Judge Andriani Nurdin, Vice President of Jakarta High Court, Indonesia, and Chief Judge Tan Sri Azhar Mohammed of High Court in Malaya, Malaysia. It is both an honor and a pleasure to join our honors as speakers in this first of its kind webinar hosted by the Judicial Integrity Network in ASEAN, entitled Justice in Times of COVID-19. Let me also recognize our highly esteemed moderator, Acting Chief Justice Shirani Tilawakardani of the Supreme Court of Sri Lanka. Our partners, retired. Our partners from the UNDP Bangkok, headed by Mr. Nicholas Booth, deserve appreciation for without them, this webinar would not have been possible. Allow me also to please greet our Philippine judges and court personnel. I think I hear them clapping right now. I did not require them to attend. I just strongly suggested that they do. And to my colleagues, friends, and guests from different countries, especially those in the ASEAN region, magandang umaga po sa inyong lahat. Good morning, everyone. At the outset, let me just say that our Chief Justice Diosdado M. Peralta really wanted to be with us and do the presentation. But he is at this very moment presiding over the public interviews online of some applicants to our Supreme Court. So you will have to bear with me. I only have maybe 11 minutes left, so let me go straight to my presentation. Like Indonesia, the Philippines is an archipelago. It has 7,641 islands, and in those islands are some 2,630 trial courts, 460 of which are special courts which hear family cases. Hence, it is not uncommon for litigants and lawyers to travel by land, sea, and air just to reach the courts. In fact, to many, this has become a challenge. The country is likewise challenged by a growing jail population. The New York Times, in an article last year, described Dorm 5 of the Manila City Jail where, and I quote, "The air was thick and putrid with the sweat of 518 men crowded into a space meant for 170, close quote. Sadly, this is replicated in many of the jails across the country. Combating the challenge of jail congestion, our Supreme Court allowed, among others, the pilot testing of virtual hearings and approved the guidelines on the use of video conferencing technology for the remote appearance and testimony of certain PDLs deprived of liberty, persons deprived of liberty or PDLs in jails and national penitentiaries in all 22 courts in Davao City, one of the most progressive cities down south in Mindanao. Our Supreme Court, steeped in tradition and held back by precedent, tiptoed in allowing the remote testimonies of PDLs as it grappled with serious constitutional issues, among which is a constitutional mandate that all accused shall enjoy the right to meet witnesses face-to-face, and our rules of court, which entitles the accused in all criminal prosecutions to be present and defend in person by counsel at every stage of the proceedings. The court reasoned that the remote appearance and testimony of an accused in a video conference proceeding shall closely resemble his or her otherwise in-person courtroom testimony and experience. The court also adopted international case law, which declared that face-to-face confrontation at trial is a preference that must occasionally give way to considerations of public policy and necessities of the case, and where the reliability of the testimony is otherwise assured. Consequently, the virtual hearings were only being pilot tested, and the remote testimony was allowed only from the jail facilities to the courts and limited only to certain PDLs. The court was very strict with the technical and operational specifications in an attempt to closely resemble the in-person courtroom testimony and experience. It provided minimum requirements for the video conferencing equipment. Among others, the video cameras must be placed in such a way as to cover the same image the PDL at the remote location would see. If he or she were physically present in the courtroom, microphones shall be connected to an audio processing device that provides echo cancellation. Audio speakers should be directly connected to the audio system to reduce latency and improve sound quality. And video monitors and screens must be in high definition and large enough for everyone to clearly see the video image, which should be as close to life size as possible. It took 3 months from the time the guidelines were approved in June 2019 to actually start the pilot testing in September of the same year. The courts and the jails had to be set up and prepared accordingly, and a seminar training presided by no less than our Chief Justice Peralta was conducted for judges, prosecutors, public and private defenders, and jail wardens. Serendipitously, the virtual hearings were limited to 22 courts only until COVID-19 swarmed some 5 months later. On March 16, 2020, Chief Justice Peralta, in response to the exponential spread of COVID-19 cases in the country, ordered that all courts nationwide, all 2,630 of them, shall drastically reduce operations and maintain only the necessary skeleton staff to immediately act on urgent matters brought before them. He, however, emphasized that the Constitution and the laws were not suspended and that the courts were not shutting down in times of emergencies. 4 days later, following the appeal of the national government for the general public to stay home and due to the unabated rise of COVID-19 infection, all courts across the country were physically closed to all court users and may be reached only through their respective hotlines and email addresses. Justices and judges on duty, however, were assigned in all areas of the country. The call of no less than the Secretary General of the United Nations, Antonio Manuel Guterres, to address, and I quote, a horrifying global surge in domestic violence directed against women and girls linked to lockdowns imposed by governments responding to the COVID-19 pandemic, close quote, was likewise addressed in our jurisdiction with the assignment of family court judges on duty in stations, cities, and provinces at any given working day. To make our courts, which could not physically open because of the virus, be more efficient, effective, and responsive to the needs of the court users during this public health emergency period, the Supreme Court, taking off from the Davao experience, immediately provided 1,000 trial courts in key cities nationwide with official Philippine Judiciary 365 accounts each, which has an email application for their respective official email accounts used for online filing and transmission of documents, and a video conference application for hosting video conference hearings. These 1,000 trial courts were initially authorized to pilot test the conduct of video conference hearings only on urgent matters in criminal cases involving PDLs. This was actually already an improvement of Davao, which only allowed 2 locations, the court and the jail. Today, there can be as many locations as there are parties. The judge can host the hearing and preside from his or her residence. The public prosecutor can be appearing remotely from his or his residence, and so is the public defender while the PDL is in jail. Also, this is not just confined to certain PDLs, but to all PDLs. Some 2 weeks later, with many of our cities still on lockdown, the court even expanded the coverage of video conference hearings to all matters pending before the courts in both criminal and civil cases, whether newly filed or pending, and regardless of the stage of trial. Thereafter, some 350 more courts were authorized to conduct video conference hearings, bringing to a total to 1,350 courts nationwide. We are happy to note that in only 3 weeks, 3,201 video conferencing hearings have already been conducted by our judges, while some 22,522 PDLs have been released since the lockdown. Some minors or children in conflict with the law were also released to their parents during this crisis. In an instant, we saw litigation transformed by technology with the least possible means and infrastructure. Through electronic transmission of pleadings and virtual hearings, PDLs were released from detention, some provisionally, some acquitted for good. Violence against women and children cases were heard, search and arrest warrants were issued, applications for temporary restraining orders and injunctions were addressed. Just last Tuesday, a regional trial court in Pampanga sentenced an American to life imprisonment online for qualified human trafficking. For all this, we commend our judges and court personnel who can also be considered as frontliners during this public health emergency. Behind the scenes, of course, were challenges. The minor ones, like weak internet signal, parties' lack of equipment, users' lack of familiarity with the system and platform, and a few gaps in the rules were easily addressed. There are at least two significant challenges, however, with the present platform and equipment being used. The first is the limited view of the judge, the accused, the witnesses, and all the parties by all the participants in the hearing. Hence, it is not easy for the judge and the accused to determine whether a witness is being coached. The second is opening the virtual hearings to the public. Both challenges, however, are not insurmountable and can be addressed in due time. Instead, what should be emphasized at this point before I end is the silver lining among all this during this pandemic, and that is the policymakers, and they are our Supreme Court justices, and the implementers, and they are the judges and court users, have been made aware through first-hand experience what technology can accomplish. This should reduce, if not totally eliminate, the biases that could stall exponential technological developments to enhance and expedite the administration and dispensing of justice. And with more people having internet access than access to our courts, without these biases, virtual access to justice can be a reality in our jurisdiction sooner than later in this digital age. All told, the new normal can be justice is accessible to everyone at all times. We just have to embrace enabling technologies that are reliable, malware-free, and COVID-free. Daghang salamat po sa inyong lahat. Thank you for everyone for your kind attention.
Thank you very much. That was very interesting because you talked especially about something I know many Filipino judges and the people of Philippines are very interested in, the safeguard and protection of women and children. And administrating courts at this juncture must be an extremely challenging job for you. And I think now they should give you, the people who gave you a hand when you started speaking should give you a very big round of applause. Thank you. I have 3 minutes to put questions to panels. I had about 6 questions, but as you know, I don't have the time and I'm bound especially by the time limits that I have set. Can I very quickly ask a question? I had thought of talking about the constitutionality, the legality, various other questions about issues concerning vulnerable people, but I will ask this one question and I will ask everyone to give me this, and that is, you know, we have all adopted new procedures. We have been compelled to, whether people liked it or not, to go ahead. It's the way forward. But can I ask, beginning with Chief Justice Menon, if I may have your attention for a minute, just to ask you, how do you make sure that orders, interim orders, prohibitive orders, protection orders, injunctions, etc., in favor of victims of violence are effectively implemented? What novel methods have you innovated and crafted to fill in the lacuna in manpower and structural process breakdowns created by the COVID-19 pandemic? I suggest you give me like a quick answer, and I'll just open it to the rest of the panel. Maybe a sentence or two. Sorry, I know we can speak for hours on this, but the most important people in this conference are waiting with their questions. So I can just give you maybe 1 minute each. Is that possible? Or
So there are just 2 points I want to make. The first is that as far as access to the courts are concerned, we were particularly mindful of keeping the family justice courts up and running because we were conscious of the fact that the difficult conditions in which we find ourselves was likely to tell in distressed conditions in families. So I talked about that in my opening remarks, the measures that we put in place to enable people to access the family courts. And we prioritized these particular issues of violence, of financial relief applications and so on. When the orders were made, once the orders were made, it is important to keep in mind that the services and operations of the court that go towards essentially upholding our work continue to be made available. So enforcement officers, duty judges, duty registrars, bailiffs, these were people who were still available. And if they had to go down to enforce the orders, they would do that. And ultimately, they, at least in Singapore, we've not had immediately a sense that this has been an issue.
all right, thank you. And also, perhaps just a small interjection, 1 minute interjection by the other judges. May I now call on Judge Adriani Nurdin, please, the second speaker? Do you have anything to say, or would you take the question later on? I think I have lost her. So may I then move on to the Chief Justice of Malaysia, Honorable Tan Sri Azhar Mohamad. May I just 1 minute, 2 minutes? Yeah.
Thank you. As I've mentioned in my presentation, that despite the lockdown, during the lockdown, the magistrates court continue to operate. They continue to hear fresh charges and even applications. And from the data that I have from the court registry, there have been a number of cases where application has been made for interim IPO, and they have been issued. But I'm not too sure whether it has been properly served, because serve is done by other agency.
Yeah.
Thank you.
Do you agree that is a problem, Honorable Jose Maidas Marquez? Do you address that effective implementation of these orders that are giving, because of the systemic breakdown, that it's a problem? If you just give me that answer, I'd be happy. Yes.
Well, for ours, in our jurisdiction, it's not a problem, because these orders can be electronically transmitted to the lawyers and the parties. And if there are violations, these violations can likewise be electronically transmitted to the court. And we can immediately send our sheriffs to physically implement in person these orders. Also, non-complying parties can be cited in contempt of court. So not much of a problem.
You complain to pharmacies, right? You have given access through pharmacies to people to lodge a complaint?
Well, the complaints will be directed to the courts which issue the orders.
Through the pharmacies, right? Thank you. Judge Nurdin, are you on panel at the moment? No, I think I've just lost her. All right. And now, can you say, would you like to say a word, Judge?
I just would like to know that this is the challenge of the other country about the gender-based violence. This is normally for sensitive cases must be conducted in closed hearing court. So conducting teleconference hearing during the COVID-19 pandemics, maybe this is may be reported through online. So do you think that this is the challenge for your country? Thank you.
Thank you. And now, you know, we always talk about judicial temperament, and the important thing about judicial temperament is listening. And so now we open up the webinar to everybody who's out there listening, whether you're in Asia or in any part of the world, to just know about, to tell you that we have your questions. We have all of your questions. But unfortunately, due to the difficulty of time, we have picked a few which seem to be repetitive questions. And I'm afraid once again, and first, thank you for those questions. And now, this is a question directed at to the Chief Justice of Singapore. For this, and it says, for the Singapore Justice, Your Honor, did you involve the other stakeholders in your business continuity plan? Prosecutors, police officers, and jail supervisors?
Yes, we certainly worked, once we obviously had our own business continuity plan. And then as we prepared it to respond specifically to this pandemic, we did work with the Law Society, which represents the bar. We worked with the Attorney General's Chambers, which represents the government lawyers and prosecutors. And we did work with prisons, the Ministry of Home Affairs and Prisons, insofar as we needed to have arrangements for prisoners to have access to Zoom facilities, for example, if there were going to be any matters affecting them or applications affecting them, charging and so on and so forth. So we did work with them. And that actually, as I said in my opening remarks, that process of dialogue was critical to ensuring that these responses were actually successful and able to work.
Thank you. Now we have a question from Ma Teresa Mauleon. Are there suggestions on the court that it would protect the child witnesses during the time that they will testify through video conferencing? How can we assure there will be no coaching or coercion during their testimonies? May I start with the Chief Justice of Malaysia, please?
I think currently, yes, thank you. I think under the current legislation that we have, even before the pandemic, there is provisions for child to give their evidence through video link to protect the identity, and there are safeguards to ensure that they are not coached. Because I think the courts will still have to will observe when the child give their evidence, and if there is any signs of coaching, I think it will be detected. I think.
May I also put the question to Jose, Honorable Jose, because I find you're particularly child-centered, because the structures, yes, we all know there was very good laws that were operative. We built up this multitude of laws to protect and care for children and to say that they have a safe environment, a friendly, child-friendly practices, victim-friendly processes. What have you, because in this special situation where we are on a virtual platform, with social distancing and everything, how do you think you can assure that? And that's, I think, an important question in the minds of all people, vulnerable people listening to this.
Yes, thank you. Like in Malaysia, even before the lockdown or this pandemic, the child really already testifies from a different holding room and not directly in court. There's already a system for that, wherein the judge can see the child and the surroundings in that room to make sure that the child is not being harassed or coached or forced to testify. So that has actually been addressed even before COVID-19 pandemic.
Thank you. I've just got a message saying I have only a few minutes more and I want to get through as many questions as possible. One from, and thank you for that question. And again, Ms. Cameron, with the issue on security of Zoom, how did you ensure that the sanctity of the court records and proceedings are kept? Important question. Can I perhaps start with, again, Justice, may I speak with the Justice of Indonesia? Adriani Nurdin, or would you like somebody else to take the question? Okay, I think so. I'm losing a little bit of contact with the Chief Justice. Again, I'm coming back to the Chief Justice of Singapore, Malaysia, and Jose. Would you like to make just short interjections, please? And
So for Singapore, we did debate it because there was a number of issues or concerns with security of Zoom. But our response to this was shaped by two fundamental points. Firstly, the basic paradigm of justice is open justice. And in a sense, we're not particularly concerned about people having access. If this was a real hearing, anybody could walk into the court and sit down. So that basic concern was much less to the fore. And what we did in the end find was that as long as we used a waiting room facility, as long as we had passwords, we ensured that this was made available to the media. We updated the media when hearings were going on. If they wanted to sit in, they could join in through Zoom. We didn't find that this was a major challenge in the end. And so, we were able to function quite well and quite satisfactorily with Zoom.
But there is a technological issue here really where they can interfere and they can actually put in, while we are having this, there have been incidents that have occurred. But I'll also go to the Chief Justice of Malaysia. Yes. Do you want to add anything?
Yeah, I just for our jurisdiction, we do not use Zoom as the platform. What we used was a Skype business. And I made to understand that there are some features there, which I think to assure that that there is less interference.
Thank
but whether,
you.
yeah, thank you.
Yeah, and Honorable Jose?
Yes, likewise here, we do not use Zoom. What we use is our own platform supported by Microsoft. And this can also be available to the public. We just have to tweak our platform to make it available to the public.
Yeah, because we keep hearing these stories, and that is an important question that has been asked. Can somebody connect me to Judge Andriani Nurdin? I can't hear her. I've sort of lost her. Anyway, I think, do I have time for one more question? I think so. Yes. The role of judge and the judiciary to ensure human rights are protected during pandemic period, and also protection of detainees' rights. Yes, of course we agree, and I think that is an important question. I don't think anybody disagrees with that, and that was only a comment. I don't think it was a question. Another question by Ajit Joy: will video conferencing introduced during COVID times continue to be a means of administration of justice in times to come, with countries formalizing it through amendments to the law? Is there a yes from everybody, and is there a no? Anybody saying no on that question?
Yes.
No. So
Yes.
Okay. So,
a definite yes.
Yes. So Mark has asked a question of the School of Law, CEU, School of Law and Jurisprudence. Certainly, there is an overriding complication or concerns relating to public transparency in digital online trials. How can these be addressed without compromising the constitutional rights of concerned parties and the court's ability to provide appropriate, timely, publicly available information? And I think, what about public hearings? How do we make public hearings possible? Again, can I have quick responses so that we can really optimize what is happening?
Is it for me?
Anybody, jump in and say if you have it.
Okay.
Yes.
Let me answer that, because that came from my student. Our platform actually allows some 250 participants to join in a hearing, and that is more or less even more than the capacity of some of our courtrooms. So that would address the trial by in public of all our hearings. That would address transparency of all our hearings.
Okay. So I am afraid that we have numbers of questions that have come in. It seems to be a very lively debate out there. I think they want reassurances, and I think every one of the questions will be directed to the panelists, and you will get email answers to it. Now, I trust we have enjoyed this webinar because it was specially for the judges of Asia, by the judges of Asia. and being inclusive, of course, for all the global jurisdictions. And I know that much relevant and sharing and learning took place. I wish to begin by saying thank you for all of the panelists and all those who made this possible. Under the auspices of the UNDP, thank you, Nick, Liviana, Sapna, Wing. This webinar was held with an objective. And what was that objective? That there was a stronger and reinforced judicial system, which survives, overcomes, and thrives amidst all the challenges and problems and resolves and delivers in an inclusive justice for all. Our lodestar must be a fulfillment that promises equal justice for all, including those marginalized, the vulnerable, and the discriminated. In the worst hour, we cannot and will not fail those who have no voice and no power, who look to our courts and to our judges, and all those, and all those who serve the administration of justice to obtain empowerment, to register, and so that they can register their pain and to obtain a fair and just resolution to their lives, problems, and needs. We must therefore, even in the worst of situations, give leadership, and through hard work, innovation, and courage, and the desire to deliver and render this service with integrity and sacrificial commitment. For we are all persons who have positions of leadership, and as stakeholders of justice must work unitedly and in a focused manner, optimizing our resources for a just and fair system that is easily accessible and which truly delivers equal and effective justice for all at all times, even during the worst times such as this. Thank you all, and may I now invite Nick for you to take over.
Thanks very much indeed, Justice Tilakawardene. And I want
and
to
you have 4 minutes, Nick.
Yes, and I shall use even less than that, because I simply want to echo your thanks to the remarkable panel of speakers that we had, the very rich sharings, the very thoughtful responses, and the very interesting and nuanced way in which all of them have been dealing with these challenges. So some of you have asked about the background papers. So we have a web page where all the background papers can be found, and we're going to write to all of you with a copy of the recording so that you can listen again. The background papers, the notes from all of the speakers, and please also fill in the evaluation questionnaire. There's a link already up in the chat, and we're going to send that link again in the email to you, because it's important for us to hear whether you enjoyed the webinar. I see that we still have 482 people here an hour and a half later. I think that's a sign that this indeed has been a very rich seminar and that people have really enjoyed it. But we'd love to hear your feedback. As I said, this is the first of our series of webinars from the Judicial Integrity and ASEAN network this year. Future webinars are going to focus on the role of artificial intelligence in justice, a very topical and interesting area. We'll have another on the very important issue of gender equality in the courts and the specific gender dimensions of integrity, issues like sextortion, bullying, and harassment in the courts. We'll have a webinar also jointly with the World Justice Project, where they will share their latest report and we can reflect on their findings. So we have a lot of interesting webinars coming up. You'll get details of all of those sent to you. And so I look very much forward to joining you all again very soon for our next webinar. But let me just close once again by thanking everybody, all of our speakers, and of course our excellent moderator, Justice Tilakawardene, for superb moderation, and everybody for your great questions. Thank you very much indeed. And I look forward to seeing you again very soon. Bye-bye, everybody.
Okay.